Hello everyone, my name is Ayşenur. I will make a presentation about ransomware. My presentation has three parts. In the first part, I will talk about the reasons of choosing this topic. In the second part, I will talk about what ransomware is. In the third part, I will move on to legal sanctions related to ransomware in the legal code. Why did I choose this topic? Let me begin with the first part. Because I read a news on BBC. It was saying that a ransomware infection affected almost 99 countries. As you can understand from this sentence, a ransomware infection is like a coronavirus infection, you know. It affects the whole world, but it is powerful because it is something virtual. After seeing that, I had made a research about it. What may be the legal sanctions about it, and I have found some articles on Turkish criminal code related to this. So that I wanted to make a presentation about it because it is very applicable to our daily life, and everybody can have such a problem in his daily life because everyone has data on their systems, or everyone uses some applications and record their information to that application. So it's something very common, and everyone can face this problem. And it is like robbery, you know. They get your money, they get your data, and they want some money in order to give your data back. Here, what is different is they want Bitcoin. They want virtual currency to unlock the files for each computer. So I have analyzed it in terms of robbery and other types of crimes in the next part of my presentation. Actually, let me move on to second part of my presentation. What is ransomware? Ransomwares target data that are valuable to the user without damaging the functioning of the system. At first, the deployment, then installation, then command and control, then destruction, then extortion. After these steps are completed, your data are taken, and what you have to do is pay money in order to get your data back. And like, what can we do to those people who gets your data, who steals your data? What are the legal sanctions about ransomware in criminal law? I have searched this. The first article that I have found related to this topic is preventing the functioning of a system and deletion, alteration, or corruption of data, which is Article 244, subarticle 2. It says that if a person deletes, bars access to your data, that person can be subject to a penalty of imprisonment for a term of 6 months to 3 years. I have given the examples of Riveton and Serb ransom. These are ransom viruses. One infects information system and prevents the user from using the information system. The other one deletes a random file from the system it has infected in every 5 minutes until $500 are paid. If you cannot pay $500, your one file is deleted. So these ransom viruses are all related to Article 244. And this article has subarticle 4, and in this article it starts with in this subarticle it starts with where a person obtains an unjust benefit for himself. Here it says unjust benefit is acquired. What can be the unjust benefits of a ransomware? They want money from you. This is an unjust benefit. They have no right to steal your data, but although they steal it, they want money to give it back to you. This unjust benefit makes it actually makes it fitting to this article as well. If an unjust benefit is acquired, a penalty of imprisonment from 2 years to 6 years and a judicial fine of up to 5,000 days is seen as a punishment, actually. In the beginning of my presentation, I said that it's like robbery. Let me be back to that. Article 148 is about robbery, and I quite related ransomware to robbery as well. In the crime of robbery, damaging the financial position of such individual is the reason of penalty of imprisonment in general, in most cases. And in this one, it is the same. On BBC, the need that I have mentioned is about this. WannaCry as a ransomware affects the data on health systems, so that due to the lack of data, the health system cannot serve the health service, so that they cannot gain enough money. This means the ransomware affects the assets, the property of the user of the IT system, so that we can consider it within the scope of Article 148 as well. Another point about this is that they want some virtual currency in order to give your data back. Like considering having a virtual currency is something very different, because there is no regulation about virtual currencies on Turkish criminal code. However, we can count those virtual currencies as state property as well, so that we can count that as a robbery as well. Normally, it should be something very concrete. However, desiring something very virtual also makes it applicable to robberies. Moving on to another article, Article 136, any person who illegally obtains, disseminates, or gives to another person someone's personal data shall be sentenced to a penalty of imprisonment for a term of 2 to 4 years. From the verse of the article, we can understand that it is also applicable in terms of ransomware, because they illegally obtain a data. What about blackmailing? Can we consider it as blackmailing? The answer is no. Why do not we consider it as blackmailing? Because in order to consider something as a blackmailing, it should be done within the duty or right of the cyber criminal, so that he does it. The article says it actually. You get an illegal interest, but you state that it was my duty or right to do that. But here, in this case, in ransomware, cyber criminal has no duty to reach your data, so we cannot count it as blackmailing. Considering that, I can say that Article 136, Article 244, Article 148 are applicable in terms of ransomware, but we cannot consider blackmailing as a crime linked to ransomware, because no one has right to blackmail you or duty to blackmail you. You means victim, actually. This is the end of my presentation. Thank you for listening.